Hello, I am Suzanne from Corrido.eu. Today, we will talk about MLTF risk assessment. In this video, we will discuss strategy, requirements, and solutions of MLTF risk assessment. The information in this video applies only to the activities of companies that are registered and operate in the Czech Republic. At the same time, 90% of the information is applicable to other European jurisdictions. The risks of MLTF, money laundering terrorist financing, mean the possibility of causing damage to a legal entity and/or the financial system through illegal money laundering or terrorist financing activities. MLTF risk assessment is a mandatory component of a system of internal rules that allows a particular company to clearly define all the procedures and processes for countering MLTF. Article 21 of Act 253/2008 Collection of Law on selected measures against the legitimization of the proceeds of crime and financing of terrorism, hereinafter referred to as the AML-CFT Act, states that all companies that are subject to this law and must have a written system of internal rules in place are also required to prepare a written risk assessment. Under the requirements of Article 5 of Decree 67/2018 Collection of Law on selected requirements for the system of internal rules, procedures, and control measures against the legitimization of proceeds of crime and financing of terrorism, hereinafter referred to as the Decree on the AML-CFT Act, company, when assessing risks, should always take into account 1. The nature of its business activities. 2. The nature of the company's products and services, and the possibility of their misuse for money laundering and terrorist financing purposes. 3. The risk connected with the use of new technologies within its business activities. 4. The risks associated with the distribution channels it uses to offer and provide its products and services. 5. Measures taken and applied to manage risks. Also, when developing a risk assessment system, it is necessary to pay special attention to the global assessments published by regulators and based on statistical data analysis in the AML-CFT area. Companies should consider the volume and types of information sources that will ensure that individual risk assessments correspond with the actual risks of the company. In particular, the decree on the AML-CFT Act obliges institutions to always take into account 1. The National Risk Assessment of the Czech Republic. 2. The European Risk Assessment conducted by the European Commission. 3. Methodological and explanatory materials of the Czech National Bank and Financial Analytical Office. 4. Information provided by law enforcement agencies and the Financial Analytical Office, records of previous inspections, and so on. 5. Information obtained during the identification and verification of the company's customers. In accordance with the AML-CFT Act, a written risk assessment must be prepared by 1. Credit institutions. 2. Financial institutions of all kinds. 3. Gambling operators. 4. Companies authorized to act as a real estate trader or broker. 5. Entities providing professional services to legal entities. 6. Companies involved in the circulation of virtual assets. The Financial Analytical Office has not developed or published any risk assessment templates, but has posted on its website some basic guidelines to follow when preparing this document. In particular, the MLTF risk assessment should include at least 1. Classification of types of clients of the company by risk factors. 2. Categorizing the risks of products and related services that can be misused for MLTF. Also, in the risk assessment, it is necessary to mention examples of signs of suspicious activity included in the system of internal rules. It is important that these signs should be indicative and not just normative. Simply put, signs of suspicious activity should be described and brought into the relevant mandatory part of the system of internal rules. However, these signs should be established from the risk assessment and directly related to the portfolio of products or services offered on the one hand and the threats typologies provided by products or services on the other. The Financial Analytical Office recommends, among other things, taking into account the risks of certain jurisdictions, both in relation to the origin, citizenship of the client, and regarding the destination of the transaction. Companies also should include the risk factor associated with distribution channels in the risk categorization of new customers. A comprehensive risk assessment methodology is considered to be the most effective. Companies should pay significant attention to risk management and objectively assess measures to mitigate these risks. It is necessary to comprehensively assess how effective the measures applied concerning each identified risk factor are, as well as whether they reduce potential MLTF risks. If the applied measures are not enough to achieve the desired result, developing and implementing additional measures is necessary. The risk assessment should be based on analyzing all available quantitative and qualitative information. However, the Financial Analytical Office emphasizes that in order to prevent MLTF, risks of different nature should not be mixed. For example, money laundering risks are of a different nature than credit default risks. An MLTF risk assessment is a mandatory component of the system of internal rules, which is a clear set of instructions. It should set out all the processes, procedures, and tools a company needs to fully comply with its AML-CFT obligations under the AML-CFT Act. In most cases, this document should be in writing. Developing a system of internal rules and a detailed risk assessment requires highly specialized AML-CFT knowledge and requirements imposed by the supervisory authorities, the Financial Analytical Office, and the Czech National Bank. Consequently, the easiest and most logical solution is to commission the preparation of this document to professionals from Corrido, who have many years of experience and understand all the necessary nuances in detail. The lack of a risk assessment system and a properly designed system of internal rules indicates a company's non-compliance with the requirements of the AML-CFT Act, which, in turn, can lead to significant fines, up to 130 million Czech crowns, reputational losses, and increased attention from fraudsters and terrorists.